Well, I'm sorry about that. There was a buzz that was going on. Did you hear it?
Yeah, it was beeping.
And then just after we'd all got we said you were around here, it went off. But we decided to stick in this court in case it happens again. Anyway, we're in the Master Rules Court, so we've got more space. Now, how are you doing, Mr. Squires? You said you'd nearly finished.
I have. I think I finished subjects of two points. One was on the relationship between our ground 3 and the ground 4 that permission was refused. I realised before the lunch jump in retrospect I was making probably some fairly bad semantic, or tried to make some semantic distinctions about evidence not accepted, rejected. Can I try again?
Have another run up.
I'll have another go. The question is this in relation to ground 3.
Yeah.
Is if SIAC made them a Bangor error, was that material?
Yes. That was sort of my question
yes.
about 1:45.
And we say the answer to that is one goes to it's page 82
of what?
A core bundle, paragraph 67, and the question one asks is, if SIAC hadn't made, and assume I'm here correct on the Bangor error, assume SIAC hadn't made them a Bangor error that's reflected in 67, at the beginning of 67, i.e. doubts, gives a basis for doubting Professor Patel's expert, that we've already explained why there is good reason to doubt, what's the first sentence then, it presupposes everything that is recorded is more likely not to be an accurate statement, and that Ms. Bow was recorded correctly. And then this line, we've already explained why there is good reason to doubt the genuineness of the account and feelings in January 2020. The question is, if you remove that,
yes, quite apart, sort of.
Yes, is it? But the question would be, for the purpose of materiality, is it inevitable that without the Mabanga error, SIAC would have reached the same conclusion? So that would be the test. If we're correct in identifying the error, is this the Mabanga error? We said it is clear from that sentence that is the Mabanga error. Question is materiality, and the test of materiality. We haven't, and I'm sure these are very familiar, but the authorities are, it has to be inevitable. No rational SIAC could have concluded, and our submission is that one does not get there. The rest of the criticisms would not enable one to say, well, it's inevitable if you hadn't made, and that is the first explanation they give. So one can't conclude, and not least, and that was my submission, if one looks at the weight of the rest of the criticisms, it's the point about as far as evidence, whether it necessarily accurately records it, and then the next paragraphs we say, their criticisms, we are not able to challenge them, but one cannot say on the basis of those, no rational SIAC, if it hadn't made the error, would have reached the same determination.
Yes.
So that's my second attempt at the relationship between ground 3 and ground 4. And then finally, in response to my Lord's question, I think about Professor Patel's evidence and where it's based, the reference to Ms. Foa's evidence in Professor Patel. So it's, I think the parts, the quotes my Lord picked up on were paragraph 62 of Professor Patel, page 257. It's the bottom of 257. She's then referring to Ms. Foa's evidence, refers to 1728, and then the quote, overwhelmed, paralysed by fear, deep-seated misapprehension. And those quotes are from Ms. Foa's first witness statement, page 132, paragraph 27. And then I refer the court to that, but I only took you to it. But that's where those various quotes come from,
Well, that was on from 26, and she's describing what she came across at the first meeting in July.
Correct. So she's then describing that, and then what was, and then this was then what.
So that's all it is.
But then what Professor Patel does is then her view is that state of overwhelm is consistent with information available about her state of mind for the whole period from arrival. So the submission we make on that, so that's then over the page.
Where's the information about her state for the whole period?
This will be going right back through her report. She then describes, and it all comes, I think, it will all come from, well, the documents that she's seen, but particularly Ms. Foer's witness statement.
So what's the reference? That's my question.
So the answer to that is it's not a reference, because this is her psychological evidence. What Ms. Foer provides is an account of what the appellant says to her and how she says she found her. What Professor Patel does is then provides a psychological explanation.
Well, I understand that.
No. So that is her. So she is, so the answer is no. That is certainly her interpretation, her psychological interpretation of all the evidence.
So what we see in the expert report is based on paragraph 27.
Sorry, those quotes are based on it.
Yes.
The overwhelmed throughout is based on the entire history that she's then recounting. She recounts throughout based on Ms. Foer's evidence. And what we do say about that, our submission is it's not surprising that the report appears like that. Ms. Foer isn't an expert. All she does is she says, this is what she said to me at different times. This is how I found her as a layperson. What the psychological expert then does is, how do we explain how she acted and why she acted? So it's very much the expert who uses the word frozen. And we say that isn't surprising. It may be that some people have sufficient understanding of themselves to say, well, yes, I knew I should act, but I felt frozen. But it's also much more like, and certainly in this case, it doesn't come from her, it comes from Professor Patel. But we say, unsurprisingly, looking at all the evidence, that is her interpretation of it. But all I was giving you, the specific quotes from Ms. Foer, the rest is her understanding of all of the evidence.
Yes, I see.
Her interpretation, the plausibility of the psychological interpretation.
Thank you.
Oh, sorry, Mr. Vice,
Yeah.
can I just raise one point,
Yes.
please? Speaking for myself, I think I'd find it helpful. Is your permission skeleton argument in either of the bundles?
I don't think it is.
I think it'd be helpful if you could maybe email that
Yes.
to our clerks, please, so that we can see how you put ground 4
Yeah.
in the skeleton argument, so we can understand that. Thank
Yeah,
you.
certainly.
Thank you very much, Mr. Grice. Yes, Mr. Blundell.
My lords. Can I take things in 4 stages? Let me tell you what they are. I'll take things as quickly as I can. I do see the time. I'm conscious my learned friend has dealt with things in some detail already. So I'll aim to avoid repetition. 4 stages of these. First of all, some very brief introductory submissions to set out the Secretary of State's case in a nutshell. Secondly, some brief submissions on the law. Thirdly, a brief factual overview by reference to the relevant documentation, again, much of which you have seen, but some of which I need to make some submissions on to put in context what SIAC said and what it was doing in its decision. And then fourthly, to respond briefly to the 3 grounds of appeal.
Thank
Take
you.
them in that order.
Right.
So part
Introduction.
Introduction, part 1. By way of introduction, in the context of applications for extensions of time in SIAC, this is a somewhat unusual case. And I say it's a somewhat unusual case for 2 reasons. First of all, unlike many, if not most of those cases, there is no dispute here about the appellant's knowledge of the decision against which she has decided now she wishes to appeal. In many of the cases, for example, the leading case C12, C11, which is in the bundle as well, there is usually a primary issue about whether the appellant has any knowledge whatsoever about the decision in
Notice.
question.
The
So
notice.
notice is not an issue here. Secondly, it's unusual for a second reason, which is that there is and can be no dispute that F4 did express a decision, and obviously my learned friend takes issue with whether that was in some way an informed or proper decision, but she did express a decision as to whether she wished to appeal within the appeal time frame in clear and unequivocal terms. There's no real issue about that. And indeed, as you will have seen on no fewer than 4 occasions in the WhatsApp voice notes, she made clear she did not wish to appeal against a deprivation decision taken against her. Again, that is very unusual for reasons allied to the first unusual point. Usually, SIAC in these kinds of applications is dealing with somebody who either says they haven't seen a notice, or if they have seen a notice, says they haven't actually made a decision on it or something of that nature. That's not the case here. It's quite an unusual case in that context. That, we say, is relevant as the background against SIAC, against which SIAC had to make its particular findings as to whether this appellant had discharged the burden on her of demonstrating that it would be unjust by reason of special circumstances not to extend time. And I will be saying that the SIAC decision is notably careful and involves a very detailed consideration of the application and the evidence before it. Equally, it didn't hide or shy away from the difficulties in which F4 and her son found themselves. On a number of occasions, it acknowledges the very difficult position of women in the camps in Syria in F4's position. But it gave wholly proper, and we say detailed reasons for not accepting the evidence she adduced. And we say realistically it can't be legally faulted. Against that background, in a nutshell, our case on the 3 grounds of appeal is as follows. Ground 1, we say SIAC did make relevant findings on the issues before it, namely whether there were those special circumstances justifying an extension of time. And in fact, even identified a reason that she did give for deciding not to appeal in January 2020, namely that God may have another way for her. So this wasn't the case of simply a burden or a lack of engagement whatsoever. And that point in my submission is significant for much of what my learned friend has said on his ground, particularly his first 2. This is not a case of total non-engagement and silence. In fact, F4 is engaging in a number of different ways. She's just refusing to lodge an appeal. It's quite specific in that context.
Well, it could be said, for my part, to be a striking aspect of this case, that she seems to be wanting to pursue repatriation on the one hand, but not appealing against the decision on citizenship.
Yes, although, of course, and this is one of the reasons why I want to take the court back to some of the documentation. In fact, when she says she wants to be repatriated, that predates the decision on citizenship. So the submission that's being made, as I understand it by my learned friend, is that in fact there are these 2 completely inconsistent submissions being made, or statements being made by F4. In fact, what happens is F4 apparently expresses the desire to be repatriated at different points before the deprivation decision is made. The deprivation decision is made and consular assistance is refused. And of course the reason for asking for repatriation was to engage the good officers of the FCDO for repatriation purposes under their consular assistance obligations. That's refused, deprivation takes place, and then she says, well, God must have a different path for me. I don't want to engage anymore. So in fact, my learned friend says, well, this is a wholly irrational presentation from an appellant because she's speaking effectively in 2 voices. Not so. We say, actually, there is a change of circumstance in December, January 2020, and all the voice notes post-date that particular change. So in fact, when you see specifically what's going on, it is entirely understandable that she may have had a change of mind at that stage. She was faced with a very different position. So we say that SIAC did reach sufficient conclusions. It didn't need to go further and identify, if that is still the case, it's not entirely clear if it is, but if that's still the case, it didn't need to identify a specific reason why she then delayed in actually appealing until August 2022. As we've said in a skeleton argument, that really is to impose a condition of the impossible on SIAC. Those reasons in any appellant's mind may not be properly disclosed. And here, the court has obviously already seen some of the difficulties that were presented to SAIC in actually trying to reconcile different strands of analysis and evidence and reasoning. But we say the key issue, which the rule, and I'll take you to the rule, requires SAIC to grapple with, is whether or not there are special circumstances making it unjust not to extend time, and that it properly did. She didn't come up to prove. Ground 2 is, of course, the ground about whether SAIC imposed, at least in this case, a test of reasonable justification. I might say, in light of the concession my learned friend, I say properly made this morning, that certainly in some cases it would be lawful to take into account an unreasonable justification, or take into account that a reason was, take into account the fact that a positive justification was in fact unreasonable. So he's not saying that in principle that is a legally irrelevant factor. It's quite difficult to see where that point really goes. But in any event, we say properly reading the passages in question, according to all the well-known strictures about how to construe a decision like this, it is clear that SAIC in fact was saying there isn't a satisfactory explanation. There isn't an explanation which satisfies the test of making it unjust not to extend time. And I will say in due course, if you read the passage in its totality, you start with lack of credibility, you have a passing reference to unreasonable, and you end with no satisfactory reason. Learned friend alights also on paragraph 88 in the conclusion. We say it's impossible to take that as meaning that SAIC throughout has imposed the wrong test, and indeed that would be inconsistent with, for example, the correct setting of the test at paragraph 56. And indeed, this morning my lady referred to the usual position with a specialist tribunal of this sort, where you assume that if they have stated the law correctly, then they've understood at least the law correctly, and very often, usually, applied it correctly. That, of course, is the A.H. Sudan principle, the Cook principle, Baroness Hale. And we say that is absolutely engaged here. So that's ground 2. Ground 3 is, of course, the Mbanga point. Well, the short answer to that is that, as my Lord Justice Holgate indicated in argument, it's impossible for any tribunal to simply provide all its reasons simultaneously. You have to have some sort of order to them. Again, stepping back from the fray, reading the reasons in their totality, SAIC produced the analysis of Professor Patel's report at the correct, we say entirely correct, juncture in its ruling. But in any event, actually gave, as far as we can count, 8 reasons for saying that Professor Patel's report could not assist because it was unreliable. And that's not to say, of course, that Professor Patel was not acting with integrity into the best of her abilities in the circumstances in which she was asked to act. But this was a case where she was purporting to provide very specific and quite high-level analysis of motivations without ever having met F4, without ever, for example, having had even a video conference with F4, for good reason. We understand, of course, why that is. Without having had any kind of detailed meeting. There was a short meeting with her mother, and without even seeing her past medical records. So it was a uniquely difficult position for her to opine in the way that she did, and wholly unsurprising in those circumstances, that the Secretary of State's own evidence, and again, another way in which this case is perhaps unusual, there was evidence on behalf of the Secretary of State on medical matters, but unsurprising that Professor Greenberg took the approach that he did. So we say no Mbanga error at all. My Lord, my ladies, that's
your introduction, is it?
That's my introduction. Can I go then to legal background?
Yeah.
Legal background, I wanted to take you to two things, if I could. First of all, the rules. You've seen it, but I think it is important just to go back to it for a moment. I'll do it very quickly. The rule is set out on tab 9 at the back of the authority bundle. Perhaps just worth seeing for a contextual submission I'm about to make how it is that the time limits work. It's Rule 8, time limit for appealing or applying for review at page 169. You'll see in subparagraph 1, notice of appeal must be given A, and there's a series of categories. If the appellant's in detention, not later than 5 days after he's served with notice. Otherwise, if in the UK, and by context, not in detention, 10 days. If outside the UK, 28 days after service. So there is a staged approach to the appealing time limit, quite a careful distinction between different time limits there. Over the page then, of course, you get the provision of significance here. Subparagraph 5, the Commission may extend the time limits in this respect. If satisfied by reason of special circumstances, it would be unjust not to do so. Before I come to specific submissions about that, can I make this first contextual point? The test to be applied is whether it's satisfied by reason of special circumstances, it would be unjust not to extend time. It is not a generalised weighing of merits or a consideration of all material considerations. You do, as case law shows, have to consider all material matters at some point. But the question, the test that is set, is about whether there are special circumstances that make it unjust, not whether it would be, for example, harsh or unduly harsh in all the circumstances. We say, for that reason, SIAC, whilst it was absolutely right to say that you don't have to demonstrate something particularly rare or unusual, I think it was rejecting perhaps a submission I was attempting to dangle in front of it at that stage. I don't seek to revive that here. Nonetheless, it was equally correct to say that there is a high hurdle here. Special circumstances you have to demonstrate, and what they have to go to is establishing that it's unjust not to extend time. That's why it's a high threshold.
Do you accept that it's not exceptional? That special does not mean exceptional.
Yes, I do. And indeed, that was specifically, if one looks at the transcript of the hearing, there was an exchange about Huang in the Supreme Court and the lack of any test of exceptionality, which I think was at the back of Mr. Justice Laing's mind when he objected to my suggestion that it might be an even higher threshold. So I accept it's not exceptional. But you have to look at what the special circumstances go to show. It's not just a general test, they have to show it's unjust not to extend time. So that, as I say, is why we say SIAC was right to say it's a high hurdle. And I'd make that point because my learned friend challenges that to some degree at least in his submissions today. And we say that's important because, of course, the consequence of granting an extension of time is going to be that you are looking at matters necessarily some time ago. In the context of a deprivation appeal, that is significant because the focus in a deprivation appeal is on the legality of the decision at the point in time of deprivation. So you have to look back anyway. And now, if you get an extension of time several years down the line, you're looking back a very long way. For obvious reasons, that may well make the whole exercise of the appeal very difficult. So it is understandable that the test is of that nature. Second contextual point is this. As I indicated in showing the court how subparagraph 1 works, there is a staged or feathered approach to time limits for appealing. The position that's been taken is not a monolithic one, where there's one time limit and that's it. The very fact of being outside the country, with all the difficulties that entails in any case, is taken into account in setting a longer time frame. It is recognised in substance that appealing from outside the UK will add effectively a layer of complexity or difficulty to an appeal. Communication may be difficult, country conditions may be difficult. These are matters, of course, SIAC is well used to hearing about in all the deprivation appeals where they take place out of the country. We say that's also an important point to bear in mind when considering one of the appellant's points about particularly anxious scrutiny, and bearing in mind the difficulty in which she is at the moment. Now, there might be quite a nice legal debate about whether strictly the Buddhist anxious scrutiny principle applies in a case like this, but certainly for the purposes of today's hearing, I am not suggesting the court should do anything other than apply the very careful approach which Lord Justice Arnold, as he was in YH, the passage my learned friend took you to this morning, said should be adopted by all judicial decision makers. Effectively what he said was anxious scrutiny has become a bit of a term of art, but nobody really knows what it means. Actually, if it really means giving particular care to important findings and conclusions, and your analysis of them, well, that applies to any judicial context. And here I certainly accept that's the case. So that's what I wanted to say about the rule. The second thing I wanted to take the court to was just the case of C12. Again, you've seen this morning, but just to make some very brief submissions.
Yes.
Again, having regard to what
Tab 7.
said. Tab 7, exactly, it's paragraph 19. As I say, this was a case where the suggestion was that somebody hadn't heard at all about a decision. And paragraph 19 is the test. Can I make, well, you will see that there are really three elements to it. First of all, there's the demonstration, and this is paragraph 1, of special circumstances. The burden is on the appellant, and the standard is balance of probabilities. So risk is not sufficient. The fact that something may be plausible.
Sorry, can you say that again? What is
Sorry,
sufficient?
risk is not sufficient.
Risk, sorry.
Balance of probabilities. And that may have some relevance when one comes to consider, for example, some of the thresholds used in Professor Patel's report, plausibility and so on and so forth. Ultimately, the test which SIAC has to consider is one on the balance of probabilities. You need evidence and not just submissions and speculations. I think Melanie accepts is not enough.
So when we're thinking about what it is that has to be established on the balance of probabilities, that means the facts, is it, on which the decision as to whether or not it's
Yes.
unjust is to be determined.
Yes, I'd accept that. I think Melanie Friend and I.
You can't, whether or not something is unjust can't be determined on
No.
the balance of probabilities, can it? It's the
No.
fact.
There's presumably the special circumstances.
Yes,
Have to be
The
exactly.
factual circumstances.
The
Special
circumstances
Yeah.
which are said to be special have to be
Exactly
special.
right. So having established the circumstances on the balance of probability, then you look at whether they meet the threshold of demonstrating it would be unjust. But I agree, the balance of probabilities must be to those circumstances. And they would be necessarily matters of fact.
Yeah. Okay.
The second point is, of course, a starting point. Again, we're agreed on this, is the explanation for the entire period of delay. But importantly, and this is the second paragraph, what SIAC in this case noted was that there may be no explanation, or no satisfactory explanation, or an explanation supported by, unsupported by evidence. Now, if that's the case, very difficult to see that SIAC needs to do anything more than say, we don't accept that the threshold is met. We don't accept that special circumstances have been demonstrated. What it can't do, and you'll have seen reference to this in paragraphs 81 and 82, is engage in speculation. It needs evidence of these matters. So there are certain respects in which the case advanced on behalf of F4 is necessarily put by way of speculation, derived from certain matters in the past, in terms of a psychological profile, whatever it may be. We see that that is not sufficient, and specifically, SIAC is not falling into error, rejecting the explanation and saying you don't get over the threshold, but not then saying at the same time, and by the way, we find that the true reason for the inordinate delay that occurred is this. It may just not be able to do that. That is to engage in an exercise of speculation, looking into the mind of somebody who did not give evidence in this case. Again, for understandable reasons, but SIAC can only do what it's able to do faced with the material it has. So we say that's wholly understandable. And then it's only after that, the third point, do you get into the relevant factors listed non-exhaustively as subparagraph 4, so merits, prejudice, importance of the underlying issue, and so on and so forth. I don't go for any of that anymore. And I won't. You've already had reference to the H2 case. That's the source of the reference there. To time limits being relevant even where you've got an Article 3 issue. That's the analysis of the Strasbourg Court in a case which is cited in H2, which is also in the bundle. So the key point I say against that background is that the authorities show that while SIAC needs to examine the explanation given for the period of delay and to decide if it demonstrates special circumstances proving injustice, there's no suggestion anywhere in either the rule or the leading case that we both agree properly represents the law in this field to go any further and make a particular finding on a particular issue which has been advanced here, namely in this case, why F4 did not appeal in time. I think I've already headlined to you why that would be an exercise in the impossible. Against that background, that's my second point, against that background, can I take the court to some of the documentary material to deal with area 3, which is factual background. Just for your reference, this is set out in our skeleton argument at paragraphs 6 to 29. And what I was proposing to do is just break down, but I only need to go to a couple of the periods really, break down the entire period into 5 shorter periods. So to give you the headline, stage 1 is prior to the deprivation decision. The reason I want to take the court there is to make good my point about repatriation.
Yep.
Exactly. Stage 2 is the appeal window. So 20th of December 19 to 18th of January 2020. Stage 3 is the first bit of the post-appeal timing from 18th of January 2020 to the 8th of July 2021, when reprieve made contact. Stage 4 is the period when reprieve were talking to F4, so 8th of July 21 to 18th of June 22. 7 meetings in that period. And stage 5 is the final post-appeal window, 18th of June 22, 22nd of August 22, when the appeal was actually lodged. So that's the period from when F4 said, yes, I want to appeal, to when the actual appeal went in.
I think SIAC dealt with that period and was sort of inclined to accept that
Yes.
F4 shouldn't be fixed with solicitors' error, in short.
Another area where my slightly bold submissions were rejected.
They were.
So, do you call
I don't challenge that at all.
You don't challenge
I simply give you the 5, so you've got
Sure.
the entire
Okay,
piece,
that's
but I
helpful.
absolutely
Thank
don't
you.
challenge that. And one can understand why the court will be familiar. There's a line of authority, BR around, FP around, about not in this
Yes.
field necessarily fixing appellants with the errors of their representatives, if errors they be. So stage 1, pre-deprivation, you've got the facts of F4's travel to Syria. I should just say in respect to that, there's obviously been submissions made about potential of trafficking and so on and so forth. I'm sure the court will understand. I'm entirely content, and indeed the court must, proceed on the basis that those are the facts for today's purposes. But to be clear, I am making no concession at all that that is in fact a correct representation of what happened. And if the appeal were to be allowed, an extension of time granted, and then the appeal were to proceed in the usual manner in SIAC, that might well be an analysis which is challenged by the Secretary of State. We haven't contested it for the moment because it's just not relevant to proceedings here. But I just want that to be clearly understood, otherwise I suspect I will have unhappy clients at some stage. I need to make that clear. So going back to the pre-deprivation stage, you get the background to this set out, no need to turn it up, in paragraphs 4 to 7 of Ms Foyer's first witness statement. That's pages 127 to 128 behind tab 4 of the supplementary bundle. And the short story is that in July and August 2019, F4's mother and cousins met with reprieve. There was some contact with F4 at that stage with regular phones apparently, and they reported that she wasn't in a good state of health. And this was said to be a reflection of what F4 had told her cousin and her mother. That leads to reprieve representations being made to the Secretary of State. I should say at that stage, and I can take you to Foyer's first statement if I need to, no reference to any psychological difficulties. The issue is about physical ill health. She is weak, she is frail, and that is the position being advanced. You then get the submissions to the FCDO by reprieve on the 29th of November 2019. You see that in the supplementary bundle, and perhaps you can just turn that up behind tab 6. So these were exhibited to Ms Foyer's third witness statement. The letter begins at page 233. You've seen it briefly this morning, just to show you the critical passage again. So it's the letter, 29th of November, under the heading, writing on behalf of F4. F4's who's detained in Al-Hal, and her son, in contact with their mother and cousin, in touch with F4 and confirm F4 wishes to receive consular assistance, including in relation to repatriation, and therefore they ask for that. Confirmation over the page, at the top of the page, that it's very urgent. And then you'll see on the third page, underlined under urgent request for assistance, requesting consular assistance to facilitate the return to the UK as a matter of urgency. Request that it be considered urgently, and Reprieve intends to provide more detailed briefing to aid decision making. And there's then some requests. That more detailed briefing is then the supplementary documentation that comes in, and certain things are particularly important in the accompanying suite of documents, which come in a few days later. There is, first of all, I ask you to turn back to the ministerial briefing that was then provided. This begins at page 198. So again, this is a ministerial briefing provided on the 4th of December, so less than a week later. For the purpose of considering her position and what's going to be done with her and others like her in the camps in northeast Syria. You've seen the summary already. On page 199, first of all, paragraph, despite her very limited ability to communicate with her family, she has clearly expressed her desire to return to the UK at every opportunity since being in Al-Hal. She is extremely close to her mother and her cousin, who are a support system growing up, willing to accommodate and so on and so forth. Now, the relevance of this is really twofold. One, no suggestion at this stage that she is in any way prevented psychologically from giving instructions that she wants to be repatriated. She's giving a very clear case. This is being advanced to ministers considering what to do with people, including someone like her, who has been assessed as being a threat to national security in the camps in northeast Syria, in a context where that person who's been assessed as being a threat to national security is asking to come back to the UK. So this was a serious document. Furthermore, of course, as you'll have seen from some of SciEx's findings and the criticisms by Dr. Greenberg, there is here material, again, in that particularly significant and serious context, being advanced to ministers about how close she was to her mother growing up, and there's other material as well. You'll see over the page 200, under the heading, her early childhood and life. I'm deliberately avoiding using her name.
Of course.
In the anonymity order. Raised in London by her mother, with whom she's very close. Cousin lived nearby, spent a good deal of time with her, describes her as bubbly and sociable, open and warm-hearted. And then you get more information about her education and so forth. That, of course, Professor Greenberg's point is that's not properly taken into account at all by Professor Patel. So I simply show you that this was a positively asserted case for a significant reason at this stage. And again, the submissions being made in this briefing are all about physical ill health and frailty, nothing about psychological difficulties. Now that's not just a ministerial briefing position, there was actually medical evidence provided as well as a report by Dr. Juliet Cohen,
Yes.
who often gives reports in these sorts of cases. That begins at 206, and again, to cut a long story short, again, no suggestion in that document that there was any indication of psychological difficulties on the part of F4. She does deal in detail.
Right, can you just give me the page reference for...
Yes, of course, it's page 206.
Thank you.
And just as you're there, the substance begins at 207. You'll see very fairly, Dr. Cohen sets out the limitations on the information she had at paragraph 2, given by her family based on her communications in that period of time, July, November. Also, brief background information on camp conditions, photographs before she left the UK, and photographs since they've been in Al-Hal. Limited information, so my medical opinion is limited. So she properly set them out. Again, I won't go through the detail, but you'll see over the page she deals with physical ill health. Reported symptoms are paragraph 13 on page 209. Series of bullet points, all physical. You'll see she's been provided with 4 photographs before. At one stage she says 1 photograph afterwards. Over the page, and again in fairness to 4, you'll see an opinion on medical conditions.
Yeah.
beginning of paragraph 17. In paragraph 19,
Yes.
you probably see,
Cognitive difficult, where is it? Function can be affected by.
yes, can be affected by vitamin B deficiencies, but that's a general statement. The summary and opinion in relation to F4 comes later, page 213. You'll see paragraph 29 onwards. Paragraph 30, very underweight, malnutrition, will affect their current health and immune system function at risk of infectious diseases, no immunisations, asthma, paragraph 32. The other problems that she's had, probable vitamin deficiencies, investigation, urgent treatment, could be life-threatening, 2 weeks to walk, etc., etc. No finding that there is any psychological difficulty, no finding actually of cognitive impairment there or anything of that nature. That was the medical position being advanced at that stage. So she's got expert non-legal assistance from Reprieve. There is probably no other organisation more experienced in this particularly specialist field, i.e. what goes on in the camps in northeast Syria, than Reprieve in this jurisdiction. She's got expert medical assistance. She's got factual assistance from her family. She also, I'll just give you the reference, had expert legal assistance because Bernard Pierce were assisting her at this stage in matters to do with consular assistance. And the reference to that is paragraph 9 of the interim grounds of appeal. That's in core bundle, tab 10, page 111. Don't seek to turn it up, but they make clear there they were involved as well. So she's got those 4 areas of assistance, all targeted at getting her back in the UK, and nobody mentions anything about psychological problems. Nobody suggests there should be any caution shown about the instructions that have been given on her behalf of the information she's provided to anybody she happens to have spoken to. So those problems, the brain fog, the paralysis, the freezing, whatever term one wants to use, weren't a difficulty at this stage. She was saying proactively and clearly, I want to come home. What happens next? Well, what happens next is, just give you the full picture, the FCDO arranged for an NGO partner on the ground to go and see her and provide some material assistance.
When do they do that?
They did that in very early December. You will get that if you go back to the supplementary bundle behind tab 5 at page 188. There's 2 emails I need to show you. This is behind Miss Boyer's second witness statement. You'll see 188, an email from somebody at the FCO as it was, 10th of December 2019, saying, Dear Maya, thank you, and so on and so forth. Third line in, given the acute circumstances, we understand that you're extremely, we understand from you that they're extremely unwell and immediate risk of starvation. We will ask humanitarian actors on the ground to inquire as to the welfare of her and her son and follow up as they consider necessary. But then obviously this is without prejudice to any decision on substantive request for repatriation. So it's a holding bit of assistance prior to any consideration of consular assistance. Then, 2 pages or 3 pages on at page 191, having done that, a few days later on the 16th of December, a second email from somebody else this time, but again at the FCO. Dear Maya, we've had further contact from our NGO partners on the ground. They've given us the following update on the 13th of December. So 13th of December now. Our people on the ground able to identify and reach them. Mother has asthma, son has severe diarrhoea. Immediate medical support was given by bringing a doctor to their camp, provided all prescribed medicines, including vitamins. In addition, winter clothes was arranged, provided immediately. Tomorrow we'll reach the non-food items team to get a separate tent and non-food items. They're currently sharing a tent with a UK woman. So there was instant assistance from the FCDO, instant assistance via its partners on the ground to give the kind of help they'd asked for on an interim basis, which went to the physical health problems. Again, no reference here, no reporting of any concerns about psychological problems, no reporting back that we also noted that she appears not to be able to engage or not to be able to do whatever. Now, I'm not suggesting, as SITE made this note, there's only so far you can go with this. It's obviously not a detailed report on everything that was done and said, but it is absolutely consistent with the picture being provided at this stage. And again, this is 4 days before you get the refusal of consular assistance and the deprivation. So That, we say, is what's happening on the ground. That takes me to stage 2, so the appeal window. And there are really 2 elements.
Can I just ask about
Yes.
on the cusp of 1 and 2? Which comes first, the consular decision or the deprivation of citizenship?
I was about to say they were made on the same day. I think it may be the case that...
The evidence is they were made on the same day, according
Yes.
to, well, let's say the evidence. I've got Ms. Foyer's statement in front of me at paragraph 8.
Yes. I think they were made on the same day, but they were communicated perhaps on the 24th of...
That's right.
Tell us that's wrong. Sorry. So I've been shown so in the pre-action protocol letter that you've heard referred to, this was a letter intimating a challenge, a judicial review challenge to the refusal of consular assistance. That was dated 24th of January 2020, and that refers to a decision of the Secretary of State for Foreign and Commonwealth Affairs dated 24th of December not to provide assistance. So according to that, I think it would be that you get the deprivation decision on the 20th, and then the refusal of consular assistance.
Ms. Foyer's statement on page 128,
Yes.
she says that the letter, the FCO said in a letter dated the 24th, Christmas Eve, that on the 20th, the Foreign Secretary decided not to assist repatriation.
Sorry, my lord is absolutely right.
Following the Foreign Secretary's decision in relation to consular assistance, FCO officials were informed the Home Secretary took on the same day a separate decision to deprive her of her nationality.
So there was an independent, and that I'm so sorry.
Is that right?
Two distinct decisions.
2 distinct and discrete, completely discrete decisions were taken on the same day,
Yes.
which were unconnected.
Well, that's what the evidence says. Now, we've not had to get into the background to that because we're only concerned with the deprivation decision here. And the challenge to the lack of consular assistance was never pursued beyond the PAP letter. But perhaps can I...
Well, there were, consular, I don't want to get time, but it's just for my own interest, if you hand it to me from Mr. Blandon. If you're a British citizen, you're normally entitled to consular assistance. Would you be not entitled to consular assistance in these circumstances if you were a British citizen?
Well, you might, even if you're a British citizen, have consular assistance refused because you're a national security threat.
Oh, I see.
Or it might condition the sort of assistance you were given. Now, we haven't had, in fact, the consular assistance refusal decision letter in evidence in these proceedings yet. So I would need to check it to see whether it matches that evidence precisely. It sounds as if what's happened is that they've said probably national security threat, therefore no consular assistance. And then on the same day, but after that, you get British citizenship revoked, deprivation of citizenship, at which point you couldn't give consular assistance if you were looking at it afresh, because you wouldn't be a British national. But given what's said in Ms. Foyer's evidence, if that order is right, there must have been an independent reason to refuse the consular assistance. Can I check that after the hearing and just confirm it to the court?
I'm probably not straying out of my lane. Again, Mr. Blundell, not for the first time this term, as I've been told last week. But so it may be not relevant. It's just struck me as an interesting.
No,
particularly there is this curious feature of the case about how she pursues repatriation. Seems to want to pursue repatriation, but not appeal. Which we're going to come on to with the voice notes.
That's right, of course.
We mustn't speculate.
No?
We're staying in our lane, but it's an unusual, a striking feature, I thought.
Yes. Of course, it's one thing to say at a stage at which you're still a British citizen and in principle entitled to consular assistance, please give me that assistance, I'd like to come back to the UK, I don't really want to stay in Al Hol, I don't think anybody would. It's something different then, once you've been refused consular assistance, for whatever reason, independent reason that was, and you've had your British citizenship taken away, still to be saying, I want to be repatriated. You may well do, because you might want to fight tooth and nail, but you may equally say, well, things have changed now. If that's what's happened, that's God's will. And that is what you get from that series of voice notes.
And can I ask one other question? Is separate consideration given to the situation of the child who is a separate British citizen?
So in terms of deprivation, well,
He's not been deprived of his citizenship.
He's not been deprived.
What about, is there a separate application for consular assistance for him? How does that work?
That I would need to check. He would still be entitled as a British citizen to apply for consular assistance. My understanding is, I don't want to speculate, but my understanding was in the consular assistance decision there was a reference to assisting him. But the easiest thing to do might be to produce the letter so the court can see it, simply to answer those questions. What I don't want to do is to suggest something based on my understanding which is not in fact true.
But the child couldn't have been deprived of his citizenship unless he was a citizen of Somalia or something.
Yes,
Presumably we don't know.
He has not been deprived.
No.
I can say that with confidence. He's not been deprived.
Right.
So he is still a British citizen. And again, an issue that does come up in some of these cases, and SAIC has looked at it recently in another case, is the difference in approach between whether you deprive an adult and then whether you still offer to help the child. It would mean a family separation.
Yeah.
So you'll have seen, of course, the references to family separations and so on and so forth. But that's in the context of the consular assistance. That would be a matter to be argued out potentially at a full hearing if the appeal were to go ahead. But my understanding
Well,
is...
there are, you can tell there are things going around in my head which I've got to try and put to one side.
Yes.
We're dealing with we're dealing with the appeal on, and we mustn't go beyond it.
Exactly, and if I can put it this way, it's never been argued, and it's never been a ground of appeal either in SAIC or here, that there was some error in how the child's position was considered. That's the legal relevance of the child to this case. So there could be a case where somebody says in some way, potentially there was some kind of best interests issue. Quite difficult to do in an out-of-country case, but not impossible. It happens. That's never been argued here. So it's simply never been asserted that the position of the child is materially, has been shown to be dealt with in a materially legally defective way. I don't want to mislead the court as to what actually happened in the decision. It's not before it. I think my understanding is correct, but thinking is not a way to make a submission. So if I can perhaps
let's both of us try to stick to within the tramlines of the appeal.
Well, I'm grateful. So, as I say, the key going into stage 2, there's really 2 documents, and I don't think I need to take you certainly to one of them. One would be to consider the voice notes. You've seen them in many different places, the skeletons, SAIC's determination, and indeed the evidence.
Where are they fully set out somewhere?
So, well, where I was going to take them from is Miss Foyer's third witness statement.
Okay.
That's probably the easiest place to get them, and I think that was nearly the last place I went to. That's tab 6.
Yeah.
Tab 6, page 192 is where it starts. You'll see at the bottom of page 192, in a voice note on the 5th of January, F4's mother told her she'd been deprived and F4 could appeal. F4's mother spoke in Somali, and you've got then the notes set out from the mother at the top of page 193. And effectively what that does is to summarise the letter. And again, just to deal with one point that came up in argument, my understanding of what happened is the same as my learned friends. The mother must have had access to the letter before it was sent a few days later to the daughter via the cousin. F4 responds, paragraph 4, on the 6th of January, message also in Somali, unofficial translation. I'm not angry, but I want to say this quickly. Please leave the appealing of the ID visa. I told you, Mum, but maybe you didn't understand me in the first voice note. Now, I go there because the first voice note has never been produced. We've never seen that. And my understanding is Ms. Foyer doesn't have access to it. I don't know if it's disappeared or what's happened, but it's not available. But there appears to have been a first voice note in which she said, I don't want to appeal. What you get at paragraph 4 is the first text in time that you see, but it's actually the second voice note. And she then says, if they take away my ID visa, if they take my ID visa away, then God may provide another way, open another way for me. If they're going to take away my ID visa, then leave it. So please leave it and do not open a case, mother. Just leave it. God willing. So 4 times she says, leave it. And you will have seen the reference in SAIC's determination to the sense of frustration that some children occasionally feel with their parents that's coming across there. You don't, as I say, have the text of the first voice note, but it seems to be to similar effect terms of what she's saying. And you'll see that reference in paragraph 6.
Yes.
Nobody-
Whereabouts in the first statement does she deal with this? In other words, she refers back to the her first statement.
So the first statement deals with it in rather less detail. And I don't think deals with all
I'm
of them.
thinking particularly of the missing voice note.
So the missing voice note. Don't-
My understanding, as set out in my...
Communications, yes. Communications are dealt with. She said paragraph 24. That's page 131. And in fact, there doesn't appear to be any reference there to the first voice note. So if you look at paragraph 24...
Well, forgive me, isn't it perhaps paragraph 24?
Well, that's what I'm looking at. F4's family shared voice messages they exchanged with F4 in Reprieve. In a voice note dated 5th of January, F4's mother told F4 in Somali she'd been deprived. So that's the long one at the top of the page that you've just seen.
Okay, right. Sorry.
And that she could appeal. She asked F4 if she wished to appeal, did not mention a deadline or inform F4 about the limited time to appeal. On the 6th of January, F4 replied to her mother in Somali, asking her to leave it, not to open a case, unsure whether she fully understood. So that's the reference, as I understand it, to what is in fact in point of time the second voice.
The one that's set out in full at paragraph.
Exactly.
119.
But at this stage, Miss Foyer wasn't saying anything about the first missing voicemail. And that was part of the problem. There was, this is before I became involved in the case, so I don't have any first-hand involvement in this, but there was a dispute about disclosure at one stage.
I see.
And that's why you get documents coming out at different stages. So again, the letter, I think I'm right in saying that Reprieve sent explaining what had happened, that wasn't produced until the third Maya Foyer witness statement. Sorry, second Maya Foyer witness statement, but not the first one. And similarly, you don't get all these voicemails until later. So that stage, you've got two of them going back to page 193. You then get further information about a variety of voicemails going between family and F4. If you go over to page 194, you'll see
Yeah.
a reference to messages on the 24th about her own condition in the camp. You'll see it at paragraph 11, I got the stuff from the health organisation. So that appears to be her acknowledging the visit by the NGO. They gave me medicine and stuff. And she said, was it you or was it the government? I thank God for receipt. And then there's an explanation about why she didn't want to move camp. Then you go over the page, and then on the 6th, you'll see at paragraph 13, 6th of January, after sending the message at paragraph 3 and receiving the response, she sent her another message, 6th of January, again in Somali, asking her to respond. You'll see what it says there. Now, I interpose after that message, what you don't have dealt with there in the chronology, but we know happened, is on the 9th of January, you get the letter. That's the Reprieve letter saying this is what you need to do if you want to appeal. Picking it up again at paragraph 14, 16th of January, and as I explained in my first statement, she sent a message responding to the letter from Reprieve, so no dispute about that. It was in Somali, unofficial message quoted below. There's also a second message reiterating the same information in English. I understand from my colleagues that this repetition was why it wasn't separately flagged. And the messages you'll see are, I don't want to complain, message 1, but I told you I don't want it. Please tell those who sent the letter, I don't want it. And message 2, I do not want the British citizenship. That second message, so the fourth in total, is significant. First, because it's in English. Secondly, because it refers to British citizenship, which is the precise term used in the letter. And you will have seen reference to a statement given by an interpreter, a translator rather, of the voice notes, who did say that the word in Somali can mean both citizenship and ID or visa, and by context we say it was obviously citizenship. But if there were any doubt at all about that, it is completely wiped away by that last message in English. And again, significant given some of the issues about understanding and comprehension that she is saying this in English. And you'll see in paragraph 15, to our knowledge, no response to these messages. Unclear whether they were received or listened to by F4. So that's the follow-up messages from the cousin it's talking about then, which is then set out over the page. You don't need to trouble by that, I don't think. So the point I make is there can be no serious issue, and there is no issue, but that she got the letter, and I'll come to that next, and no issue that she said, I don't want to appeal. But we say it goes further than that. And to the extent my learned friend maintains in his ground one that she did not understand, we say that's an impossible submission. It is quite clear by context, by the responses she was given, and particularly when you see what she was told in the letter, that she understood exactly what she was doing. Not least because she gave a reason. It may not appear to anyone sitting in a court in London a terribly good reason that God may have a different way for her. But of course this was somebody who had done some things that people in courts in London might find slightly surprising, like travelling to Syria and, on the Secretary of State's case, aligning with ISIL. So we say she did give a reason, she did engage, she knew what was happening. Now, I've mentioned the letter. Can I just go back very briefly to that? Again, you've seen it, so I can be brief. That is in the bundle behind my foyer 2 at page 163. And again, I repeat the submission I made in SIAC, which SIAC accepted. This is a model of clarity and concision as well. It's not a very long letter. It tells her everything she needs to know, explains who they are, explains the connection with her family, who we know from the ministerial briefing were being treated as people she had a close bond with. Effectively asks her to really consider very carefully whether she wants to appeal. They say what's happened. They say, we think you've got good grounds to challenge this. Importantly, at the bottom of the page, no money. Don't need to worry about funding it. Over the page, here's how you do it. 2 routes, an appeal, judicial review. Significantly, we would keep your and your son's identity secret. So no issue about confidentiality. That would be a legitimate concern. The court will no doubt be aware that sometimes it is said that women in the camps who are seen to distance themselves from ISIL face a real physical threat from some of the more radical elements in the camps. That might perhaps be more the case with Al-Hal than Al-Roj. But certainly that is a submission that is often made. But this is all going to be confidential. Nobody needs to know. And then here's what you need to do if you want to come home. Don't pay, keep your name secret. And then again, consequences. So again, at the top of the page, we should do this because it would be very hard for you ever to come home to the UK or even visit if you don't try and keep your nationality. And then, again, almost level with the second hole punch. If you think there's any chance, you do not challenge the decision to take away your British citizenship now, it'd be much, much harder for you to come back home with your son. If you think there's any chance you would want to come back with him or to continue to be a citizen, I would suggest you appeal now. It will be very, very hard, maybe impossible to do this later. You can always withdraw the appeal if you change your mind. That sentence is actually just as important as anything which goes before it. If you've got any doubts at all, just appeal. You can always withdraw it. And again, that happens. There are cases where appeals are withdrawn or stayed. A number of these decisions from women in the camps were stayed after the Supreme Court's decision in Shamima Begum's case because of difficulties on the evidential side very often. What are next steps? Well, there's only one thing you need to do. Can you write these words on a piece of paper, page 165, date it, take a photo, and send it to your mum? And that then is what she refuses to do on the 16th of January. She sends those voice notes. I've got the letter, I don't want to do it. I don't want my British citizenship. Now again, bear in mind that a mere 5 or so weeks before this letter is sent, she had given authorisation, effectively, it was being said on her behalf, that she wanted to come home. She was asking to come home, and there was no suggestion that she had any psychological difficulty in grappling with that concept. And yet suddenly 5 weeks later, everything's changed. She has brain fog, she has paralysis, she's unable to act, she's frozen with fear. Again, I want to be careful with my submissions, because I'm not suggesting that the position in the camp is anything other than extremely difficult for someone in her position. SIAC took the same approach. What you cannot say then is that she wasn't engaged, she wasn't thinking about it. She was repeating herself many times consistently. She got the negative decisions, and that is what changed. It wasn't her psychological condition. She changed her mind because she'd been refused consular assistance and deprived of her citizenship. That was the only change on the ground. So there's no inconsistency, as my learned friend suggests, or rather, there is a very serious inconsistency with those two positions, but she's in fact not running them at the same time. She changes, she has a change of mind. And the mere change of mind, absent some psychologically significant motivating factor, which means she couldn't properly think, nobody has ever suggested would be sufficient to engage the test in Rule 8.5.
The request you've just been referring to 4 or 5 weeks beforehand,
Yes,
is that the one made by Miss Furr?
that's the one made by Miss Furr, yes.
Pursuant to the authorisation given by the mother?
Yes, on the basis of conversations the mother had with F4 and her cousin.
Where do we get that last bit?
You get that, go back in my notes. Yes, so I think you get that from Maya Foyer 4. Yes, if you turn Maya Foyer 4 is behind tab 7, begins at page 238. You'll see paragraph 2, it's my fourth statement, purpose to respond to a suggestion made in a respondent's skeleton argument. That was, I think, a skeleton argument drafted by Miss Giovanetti rather than me, but I forget now. The suggestion is based on a letter of the 29th of November, so that's the consular assistance request. Respondent points to this section of the letter we write on behalf of the above named. Suggests, therefore, has sufficient clarity of thought and ability to agree to reprieve requesting consular assistance in November, can therefore be inferred she had a similar level of clarity of thought in January 2020. In light of the suggestion inference, I think it's important to provide additional background. In summary, this is paragraph 4, the reference to F4's wishes in the letter reflected F4's desire to return home, a desire she had expressed to her mother and cousin, who in turn relayed it to me. F4 communicated this when she was still a British citizen. It was different from the situation in January 2020, when F4 was presented with information about the deprivation of citizenship. Well, in a sense, that's true. That was the difference. In January 2020, she'd been refused consular assistance and deprived of her British citizenship. But it's unclear, and there's certainly no basis in the evidence as far as we can see, to show that there was some psychological change in that time, as opposed to just a change of mind. But that is why I say, my lord is absolutely right to say the authorisation was an authorisation given by the mother, but it was in the context of F4 saying, I want to come home. That's what the mother was expressing. And indeed, the reason why that is important is because had F4 not communicated that kind of desire, the mother might be acting contrary to her best interests, certainly contrary to what she wished to happen. And you'll see a little bit more detail about paragraph 5, saying in a meeting on 25th of October, F4's cousin told me that in April, she said she'd wanted to come back home, took it very seriously. F4 expressed this spontaneously, not in response to a specific proposal. F4's mother confirmed to me through a translator she communicated to her she wanted to come home. Following the October meeting, we discussed her case and desire to come home and drafted that letter. So it's absolutely foursquare and consistent with that. So those are the key documents in the
Thank you.
appeal period. That's stage 2. We say abundantly clear she knew what was going on. No contemporary medical evidence of psychological issues. The only contemporary medical evidence was physical problems only, Juliet Cohen. Stage 3 is the post-appeal window. So that's 18th of January 20 to 8th of July 21, where she meets to reprieve. Don't need to say any more about that. Although I will come on to it in ground, I think it is 2. But the long and short of it is that there was no communication in that period that's relevant to any of the issues here. Stage 4 is the post-appeal window 8th of July 21 to 18th of July 22 when she decides to appeal. Just given the time, can I take that from my skeleton arguments? Paragraph 28, where we set out our understanding of what the meetings were. In fact, you see it really beginning at, it begins slightly earlier in our skeleton. We provide some more detail about it. Paragraph 22 is where this begins. There's all the detail of what was being done, what was being said. And then all the way up to 28, which is where you get the summary of what we understand to have happened. So reprieve met on 6 occasions, July, December, and then the following June, over the course of nearly a year, before she indicated on the 7th occasion that she wished to appeal. Of course, what's notable about that suite of meetings is that it's in the very first one that she provides authorisation to reprieve to act on her behalf in a variety of effectively repatriation and other matters, including legal proceedings. Again, no suggestion that in providing that authorisation, she was in any way disabled by psychological paralysis or freezing or brain fog. It's not clear, and that's the difficulty with the evidence. It's not clear what happens. Did the fog momentarily lift? She could give authorisation for certain purposes, but not others. And of course, it's relevant if one's considering the credibility of an explanation being given not in July 21, but in October 22, after the appeal has been lodged, and she's being asked, why didn't you appeal earlier? But she then says, oh, well, it was all brain fog. We say entirely unsurprising that Syke ultimately concluded that was not credible. And then, of course, you've got the post-appeal window, 18th of June 22 to 22nd of August. I won't revive my bold submission on that. No more challenge to that. My Lords, my Lady, that's stage 3 of my submissions, which leads me to my final stage, which is the ground.
Yes.
Can I go through? I'm going to take the grounds in the order in which they're pleaded, 1, 2, 3, as it were. Ground 1, first of all, which is the alleged error in failing to determine the reason for the delay in appealing. My headline submission on that is that there was no error at all in Syke's determination. It found, I'm going to go through the determination now because I haven't been to that yet, but it found that F4 had failed to demonstrate special circumstances which would make it unjust not to extend time. It made relevant findings in that regard, including on certain issues as regards credibility. The fact that it did not say, we positively find that the real reason she didn't apply early and the real reason she waited for 2.5 years is as follows, is irrelevant because A, that wasn't the question it had to answer, which was whether there were special circumstances making it unjust not to extend time. It did answer that question. It said there aren't such circumstances. She hasn't discharged the burden of proof on that. But secondly, it did deal with, consider and reject the case as it was advanced in all relevant respects. On behalf of F4, it didn't in those circumstances need to go any further.
Did it deal with the freezing point? Because the way this ground
Yes.
1 seemed to morph
Yes.
this morning was that emphasis was placed on that, and it was said that that wasn't dealt with at all.
Well, I don't accept that's the case, and I say between paragraphs 60 and 78, it was precisely dealing.
Sorry,
between paragraphs 60 and 78, it was dealing with the. It doesn't use the term freezing, but it doesn't need to. It's dealing with her inability to engage. So this point has been called different things at different times: psychological paralysis, freezing, non-engagement, a range of different things by different people at different stages of the process. As we understand the argument put this morning, it's all going to the same point, and that is what it is. Can I take the court then to this, because that is the kind of the focus of the ground today? Can I ask you to turn up Syke's determination in the core bundle, but starting at paragraph 56. So the whole thing begins at page 60. 56 is where you get the discussion. You see a case centres on being able to show on the balance of probabilities it's more likely than not that her voice note statements, making it plain she didn't wish to appeal, were not the product of a properly formed decision on her part, and that consequently what occurred in 2022 cannot be described as a change of mind on her part. Now I pause there, the submission I'll be making in due course is that that effectively answers any issue about AH Sudan. That is a totally correct statement of the issue SIAC had to determine under Rule 8.5. Then it moves on to consider the position she's in. On the face of it, the voice notes couldn't be clearer, you see at the beginning of 57. It sets out what they say. Then there's reference to the reprieve letter, which they agree at paragraph 58 was a model of clarity and simplicity. 59, she's got about a week to consider that, then deals with her further voice messages. That's where you get the finding as to the significance of British citizenship in the middle of the paragraph. The last communication is significant for two reasons. First, in English, so there can be no doubt at all as to what she was intending to communicate. Secondly, the expression British citizenship as opposed to nationality occurs 3 times in the reprieve letter and in the voice note. Including the suggested form of words of instruction, we find it's highly likely that her use of this expression shows that she had read the reprieve letter in its totality. All of this means that her case faces a significant hurdle, and this is where you start to get the engagement with effectively paralysis. She must show it's more likely than not that the context in which the communications were sent was such that she was not expressing a decision based upon any material engagement with the question of whether she should appeal, but rather she was in such a mental state that she did not appreciate the significance of the deprivation decision, or that she was not prepared to engage with it because all her mental and physical resources were needed to keep her and her son alive in the challenging conditions of the camp. Now I pause there. The focus this morning was very much, again, entirely understandably, on paragraphs 81, 82. This bit's critical because this is where SIAC is engaging with this issue. The suggestion that it hasn't taken it into account simply doesn't run. It knows what the case is she's advancing, it understands it, it puts it in the language of engagement. I don't understand to be any suggestion that's different from paralysis or freezing, and it explains why. So then you get the 861 reference to it being in October 22 that she's first asked to explain what she'd understood when she was approached about appealing in January 20. And it makes the point there that at this point she'd already decided she wished to appeal. So if her statements in January 20 had represented her freely formed decision not to appeal, it was plainly in her interest to try and overcome the obvious difficulty. There was a motivation in her explaining this away at this stage. And of course this goes to credibility, so it's a fair point to make. Then it explains why the passages Malone and Friends still relies on in Miss Foyer's first statement need to be approached with some degree of caution. And you'll see in the middle of 62, even though her state of mind may have been very suboptimal, it's difficult to understand why, if she was in doubt, she did not express that to her mother and cousin in the messages. Instead, and in marked contrast, the messages exhibit a degree of frustration, which a young person may often feel towards a parent who, in their eyes, is badgering them to do something they've decided not to do. I think any parent probably recognises that. Then there's the contradiction in the statement at the beginning of paragraph 63, which is important. As presented to the Commission, her case was that she wasn't able to reach a decision in January 20, owing to her mental and physical state and concerns for the health of her son. So picking up the themes you see introduced in paragraph 60. Paragraph 40, however, talks about F4 describing rumours about what would happen to detainees. Now,
Sorry, where?
sorry, paragraph 63.
Paragraph 63 in the reference to paragraph 40.
I'm so sorry.
Sorry, my mistake.
No, it's confusing. I should have made it clear. So paragraph 40 of Ms. Foy's statement refers to the points about rumours. Now, this was a point that came up in argument for my Lord this morning.
Yes.
It's not specifically relied on, but the utility of that analysis and the reason why SIAC alights on it is to countervail the suggestion that she was incapable of engaging. Actually, she was capable of asking perfectly intelligent questions and raising perfectly understandable concerns. I'm hearing rumours. What does this mean?
Just so I'm clear, this is what she's saying in July 21, or July,
I think October
post July
22.
October 22. Sorry, I mean that.
Exactly.
Post Miss Foy going, in the period when she's engaging again.
Exactly.
Looking back
Exactly.
Yes.
So she's appealed by this stage. She's now explaining why she didn't do it earlier. So bear in mind, of course, what Syke says about there's a motivational issue here. So that, as Syke entirely reasonably
Can I just ask, there's no reference to this point about transfer to Iraq before this point in the chronology?
No, it's not. It's not
raised by F4.
No, exactly.
Or anybody else before this late stage.
Exactly. She's not. That's right. And she is not in these proceedings, these appeal proceedings, relying on it to say there was some error in the way that was approached. What it shows you is the Commission think extremely carefully, in a very granular way, about all the evidence of what her mindset was at a particular time. They said, well, this is not somebody who is not engaging. This is somebody who's engaging and saying, well, I'm concerned about these rumours in the camp. What's that going to mean for me and my son? That's not paralysis. And you see that if she was questioning what Mother and Reprieve were telling her about the position of the UK government, sits most uncomfortably with the suggestion she was not in a psychological position to engage with the information provided to her about deprivation of citizenship. So again, this is another reason why I say the suggestion that Syke somehow didn't deal with the psychological engagement issue does not get off the ground. It was dealing with it absolutely front and centre at this stage. Then you get paragraph 41 again of Miss Foyer's statement, afraid of what would happen to her and her child. You get the reference to the contradiction with the stance taken before Syke, as well as contradictory with the other bits of paragraphs 37 to 39. And it explains why that is in the remainder of 64. Beginning of 65, any suggestion that in January 20, she feared repatriation might have that effect on arrival is undermined by the letter of the 24th of January. That's the pre-action protocol letter that's been referred to, challenging the consular assistance request, threatening judicial review. This letter, it says, written after the deprivation decision taken, communicated to Bernberg Pierce, F4's mother, and F4 reiterates her desire to return to the UK with her son. Now, it's not clear, perhaps, if F4 had provided separate instructions for that letter. There's obviously a limit to which one can inquire about these things for reasons of legal privilege. But certainly there's been no reference to any further communications in that passage of time. Either way, it sits very uncomfortably with the suggestions that are being made.
Have we looked at that?
You don't have it.
We don't have it, do we?
No, it was... so I think the position before Syke was that Secretary of State wished to have it in the bundle. There wasn't agreement about that. I think I handed it up. Yeah.
Well, this was not shown to Syke.
Not. That's what I'm just checking. We had it ready to hand up. I'm not sure. I come back to the court on that. I thought we'd handed it up. It may be that we didn't, but we had it ready.
So Syke's referring to it in the judgment.
It does.
When it says the letter reiterated her desire to return.
So I think we must have handed it up. We must have handed it up.
Is that right, Mr. Scott?
I wasn't.
My speaking notes I checked yesterday,
Miss
the Syke hearing, and in my speaking notes I had a note to myself to hand it up.
I mean, there were quotation marks around it, which suggests Syke is quoting from something, but that's, I can check.
Sorry, where are the quotation marks? There are quotation marks in the previous paragraph.
You're right, sorry, no, that's a bad one.
We're at paragraph 65. I mean, if I'm barking up the wrong tree, both of you tell me.
But I'm sorry,
It looks to me as though,
ignore me.
what you think. Looks to me as though Syke either saw this letter or saw an agreed summary.
I can certainly say that we had copies, and my note to myself said handed up. I checked it yesterday, and my recollection is that I did. And in my submission, the reading of that paragraph, for example, particularly the sentence in the middle, this letter written after the deprivation decision being taken, etc., reiterates her desire to return to the UK with her son.
I mean, it sounds as though
Sounds as if it had
did
it.
have the text of the
Yes.
letter and
It
were
does.
summarising it.
That's how it reads, isn't it?
Yeah.
And it's not unimportant in Syke's reasons for rejecting
Yes,
part of the explanation.
that's right. It's a relevant consideration, so it takes into account. You then get to paragraph 66, the beginning of the passage on Professor Patel. Now, I'll come to this in more detail when I come to ground 3
Yes.
in due course. But the short point to make about it here is it is not dealt with after the findings of credibility have been made as a simple Mibanga-style add-on. It's right in the middle of the consideration of all the issues. As my Lord Justice Holgate said in argument this morning, SIAC can't produce all its reasons simultaneously. It has to order the documents and each bit of the reasoning in some way. And in my submission, that's what it's doing here, but I'll come back to the analysis on that later. I'll pick it up again after the Patel material is on page 84, paragraph 73,
Yes.
where you get again reference to the asserted mental state. Further doubt on it is cast by the material reprieve supplied to the FCDO in the November 2019 request for repatriation. And this is the point I made when taking you to that documentation. No reference is made to any concerns the family had about her mental state. Briefing contains considerable detail about her physical condition. And then you see the reference to Dr. Cohen over the page, just above the first hole punch.
Yes.
This aspect of the report serves to emphasise the significance of the lack of any suggestion by the UK relatives to reprieve or Professor Patel in their interactions with F4. The relatives F4 thought she might be exhibiting such symptoms. They were very clear about the rest of the symptoms she had. Briefing document paints a significantly different picture, 74, of her life in the UK. And this is the point about them being, the family members being close, being bubbly and sociable. So against that background at 75, they say it's significant that no witness statements from F4's mother or cousin were provided. They would have been able to shed light on it. And then no mental issues, 76, identified when she was visited by FCDO's NGO partners, the emails I showed you in December. They rightly acknowledge the limited nature of that information at 77, but they would have expected the things to be noted. All of that stems from the initial reference to lack of engagement. And that's where it's treated. That takes you to 78. And that's where you start to get the conclusions. On the state of the evidence before the Commission, we conclude she's failed to show a balance of probabilities. Her voice note statements of January 20 should not be read at face value as representing her considered decision not to appeal against deprivation. And they say we're not minimising her difficulty, but that's where we've got to. So,
So, yes, carry on.
So full engagement through several pages in an extremely granular way with the suggestion of non-engagement, freezing, paralysis, whatever you want to call it. And that leads to that conclusion. So it was considered, it was dealt with, it was rejected.
So there we find SIAC, thinking of C12, and the rule, making a finding about the circumstances on a balance probabilities.
Exactly.
I mean,
Exactly.
with the burden of proof on F4.
On F4.
And that's the context of paragraph 79.
And that's the
where they
context.
go on to say, even if F4 was able to overcome that point, and this is where we get the reference to satisfactory reason.
Exactly. And sorry, and I can very grateful to Milena Jr. as ever, who has referred me to the transcript in a.
We've got a transcript. We could have checked.
We have.
Well done, Miss Parsons.
Yes. As ever, she's telling me the right thing. It refers to an embarrassingly long section of monologue from me by the look of it, several pages. And at page 50,
I'm not surprised she remembered that.
same old story, she probably said, he's at it again.
Yes.
At page 59 of that monologue, all completely right, of course, you will see at the top of
Where is it?
I'm so sorry, so this is supplemental bundle, page 59, behind tab 1.
Which hands up letter. Is that what we're going to see? Is that what you're showing us?
It's the
Line 4.
Line 4 exactly. Hands up letter exactly. Exactly.
What page? 50 what?
59.
59.
I've referred to the pre-action letter as well. Do not think I've taken you to that yet, but perhaps if I can just highlight a couple of paragraphs there. This is the one it says at the end of the bundle, and if you say, you'll see it's urgent. So I've handed it up at that stage.
Okay, well done, Miss Parsons.
At this point, I should probably sit down, but she may not thank me for that.
Yes.
So that's the answer to that. That's the answer, ultimately.
So we just, thank you very much, that's clear. So we then get on to...
Well, I noticed your submission at the foot of page 59, lines 34 to 35.
Sorry, I shouldn't have put it away.
Quite.
Yes.
Having taken them through.
So this letter was therefore definitely before signing. Do you want to see it?
Exactly. You'll see engagement.
I think we'd like, is there any reason why we shouldn't see it?
We can hand it, we've got copies.
I think
Hands up left.
Hands up.
hands up letter.
So one day in the Supreme Court, I'll remember what happened this time. Could I just hand that? Not that I'm suggesting this case should go any further, for either party. Thank you very much.
Thank you. All right, should we have a look at it? Oh, it's quite long. What do you want to do? Do you want to read it? We're reading, unless you want us to have an eye to the clock. Do you want us to go through it now? Or
Oh, I'm so sorry. I wasn't asking the court to know. There's nothing I particularly need to go through.
We've now got it.
Yes, you've got it.
I hope you've not been taken by surprise, Mr. Squires. If you,
No,
you're reminding yourself of it. Now, okay, unless you want to say anything about it, let's go back to where we were, which is page 86. Oh, you're looking at something else now.
sorry, my very learned junior again has just indicated to me she's suggesting the chronology was that both decisions were taken on the 20th.
Yes, well, that's what is said somewhere.
Yes. And the FCDF, so the and on
Letter
the
was
20th,
dated the 24th.
That's right, so they're both
That's
taken on
what
the
Miss
20th.
Foy said, I think.
And on the 20th, they served to file the deprivation decision. On the 24th, the FCDO writes giving the decision in the refusal.
That's right. That's what's said in some. We've seen
Exactly. So that would appear to be right.
Okay, can we go back to the judgment
Yes.
then? So that we're on page, we've just got to 78, where
Just
you've
got
attempted to show that the finding on the circumstances about the voice notes at top of 78.
Yes, exactly.
And then we were going on to 79.
You've got a finding there. And even if you get over that, you've then got this additional...
And that's introduced by reference to the satisfactory reason.
Exactly. So they've applied the right test. They've said failed to show a satisfactory reason. And of course, what you know from C12 and the rule is that you have to have satisfactory reason for the whole period. So actually that finding would be enough on its own. What it does then is say, even if you could get over that problem, and if you ignore the period of apparent silence, which now appears to be covered by the paralysis or brain fog, to July 21, the Commission is not satisfied. F4 has shown the balance on balance. There was a satisfactory reason for her to delay until June 22. And again, there's references to Ms. 47. So again, that's important in looking at ground, and I'm really now morphing into ground 2.
Yes.
So ground 2, of course, challenges in particular a finding made in respect of that second period as regards the use of the word reasonable. But the start of the analysis in 79 is actually again to apply the correct test in express terms. You can't take paragraph 81 and salami slice it so that you get the word reasonable without either the rest of 81 or indeed the rest of these passages. So you start with the right test in 79. Then you go over to 80. You see again reference to Miss Foyer's experience with women in camps. Importantly, of course, at this stage they're dealing with suggestion that detainees don't have legal advice or means of communicating. Emphatically not the position with F4, which one might think to be absolutely correct in terms of the experience and expertise she was having provided to her. She did access advice from Reprieve, who'd been acting for us in 2019, had written to her in 2020 in terms which were entirely satisfied she understood. So that's also where you get an important finding that she'd understood it. No challenge really to that. Furthermore, F4 had access, albeit indirectly, to Bernberg-Pierce. I've given you the reference also to what Bernberg-Pierce said about that through their submissions, the interim appeal submissions. Then you get 81, fundamental contradiction. Here, Miss Ford is recording that on the 10th of July, she gave authorisation to assist her, manifests that it would enable her to come back. But it was, however, as stated clearly that once in the UK she'd be separated. As we've observed, the authorisation says that the effect of giving it had been fully explained in language she understood. And as to the consequence in those circumstances, it's simply not credible. So you start with the right test. You then have a finding of credibility that she would, on the one hand, give the repatriation authorisation and on the other refuse to appeal. And that's your finding. It then goes further, possibly didn't need to, but it seeks to go further. So there's only three possibilities. Either Miss Foyer's recollection is incorrect, that's unlikely. Second possibility is that she may have expressed herself like that, but did not genuinely believe it would have that effect, and that is possible. Although you can't ascribe that to brain fog or any other similar cognitive disorder, such as alleged to have been the case in January 20. But in any event, that's not her case. And then you get the A, B and C findings. So A, she was feared British authorities taking them. B, authorisation was so inconsistent with her alleged fear about appealing it that it made it likely that her alleged fear was not genuine. So again, findings of genuineness or otherwise.
Yes. And then the reference to motivation in the last penultimate line.
Exactly.
That's the motivation if it's the second possibility, is it?
Yes, because
Yes.
it's not the cognitive disorder.
Yes.
It's not the cognitive disorder.
Exactly.
It's not F4's case.
Exactly.
But
Given
we-
A, B, and C, it can't be her mental state. So if it's the second possibility, her motivation for not genuinely believing must lie elsewhere. I'm sorry,
That must be
is
right.
that right?
And it then gives the
And
warning.
don't speculate.
speculate.
Don't speculate. Entirely proper, not least because if it started to speculate, it would breach the strictures of C12.
Yes, there'll be a different ground of appeal.
Different kind of appeal. Yes, exactly. So it's walking a tight rope here.
And then there's the third possibility. What do you say about 82?
So the third possibility is, despite the advice and obvious illogicality, she genuinely believed there was some relevant danger in appealing. And that's where you get the reference to unreasonableness. But the point about unreasonableness there is you can't read that, and that's where the complaint comes. You can't read that outside all the findings about credibility, lack of genuine belief, the correct setting of the test, and then the ultimate conclusion, which comes over the page at paragraph 84. If you look at the final sentence of paragraph 84, it does not, however, assist the appellant, because even if one ignores the period from 18th of June, so this is them rejecting my bold submission, there is no satisfactory explanation for the delay from January 20 to June 22, which was extremely long. So no satisfactory explanation. It's applying the right test again. So it states the test correctly at the start, states the test correctly at the end, talks about credibility and lack of genuine motivation.
And makes a finding on credibility.
Makes a finding on credibility.
And then goes on to talk about these three possibilities,
Exactly.
which are subject to the principal finding of credibility.
So it's a principal finding of credibility. It says don't speculate. Seems to toy with a little bit of speculation, admittedly, in 82. And 82 is it is a slightly unusual paragraph, 81. I can completely understand why that point is
that's where reasonable appears.
And that's where reasonable appears. But that's having given itself the warning not to speculate. It's trying to do the best it can in a very, very difficult situation. Because, no doubt, it had at the forefront of its mind, as it said more than once, that the conditions were very difficult and the consequences were highly significant of finding that she was out of time. So it was trying its best to consider every possibility here. But in that context, when it says plainly entirely unreasonable, there are really two answers. One, in my submission, you have to read that as being a finding that's just not a satisfactory answer. That's what they mean by unreasonable there. They really mean not satisfactory. And that's because you've got not satisfactory credibility, not satisfactory. So don't have a kilter with that. You can't salami slice it out of the passage of reasoning in which it occurs. But secondly, the learned friend rightly accepts that in principle, it's not a legally irrelevant factor. It turns on the facts.
And it seems to be expressed in terms of the facts here.
Yes.
And it may be the way to read this. It's a reference back to the very nature of the contradiction.
Yes.
Because you can get all sorts of contradictions.
Exactly.
And this one is particularly striking, is what the tribunal seems to be saying.
Absolutely. And again, bear in mind, I said the entirely fair way when learned friends put it today. If it's not in principle a legally irrelevant factor, it can only be legally irrelevant by circumstance or by virtue of the particular facts. But the particular facts here are utterly striking that you have these two contradictory positions.
And it, if SIAC had said the test we're applying is whether or not there's a reasonable explanation, that would be different. But they keep going back to the right test, and the right test is stated again in paragraph 85.
Exactly.
So, yeah. So
And joining all the dots together and reading it as a whole, it's in the context of the tribunal having found there was no cognitive disorder.
Exactly. Exactly.
I mean, it would be different if there was a contradiction, perhaps arguably less stark, but where there was. So it's fact specific.
Well, it would be very difficult to say if they'd made the contrary finding that there was a cognitive disorder, but nonetheless we need to look at the circumstances here and then say, well, that was a completely unreasonable finding. In the context of somebody with a cognitive disorder, it might be an entirely understandable, if objectively unreasonable finding, and then excluding it might well be unlawful, but that isn't what they've done. They've said no cognitive disorder.
right, I'm conscious of the time.
Yes.
We've dealt with ground 2, I think.
Grateful.
And what do you want to say? I'm pushing you a bit. Have you said all
Yeah, my lord, I'm satisfied. Unless there are any further questions from the court, I've dealt with the issues I wanted to.
And then ground 3.
The only other point I was going to raise, just about, and simply to give you a reference, on ground 2, we say the error is actually, with respect on the learned friend's part, he falls into the error described in Volpe and Volpe, which is quoted paragraph 10 of My Lady's judgment in U3, in terms of how an appeal court looks at facts.
Yeah, well,
You've got that in the scansions.
we have Volpe ingrained on our hearts.
I thought my lord might say that. So, ground 3. Ground 3 is Mbanga. We say that goes nowhere. This was not a Mbanga error, nothing even remotely close to it. Again, just for speed, can I pick it up from paragraph 57 of my skeleton argument?
Yes.
You'll see where we do this. And really, there's 2 headline points. One is that SIAC can't produce a sort of brain dump of all its reasoning in one go, which is sometimes where I'm not suggesting that's what my learned friend has said. He's obviously made a much more sophisticated.
Well, you've covered some of this already. You've said
Yeah.
in 57, that's the Commission setting out the problems with Professor Patel's report as set out in its PTA decision. And then you say you sought to demonstrate that in fact the analysis of Professor Patel in the judgment of SIAC comes before the definitive finding on credibility.
So it's wrapped into the findings as they're made. It comes before the definitive finding on credibility, and they gave in fact 7 reasons why Professor Patel's report was not acceptable.
Yeah.
In a context where they had opposing evidence from another professor on behalf of the Secretary of State. So we say not Mbanga and not even close to it. Well, may I just turn my back for a moment?
Yeah.
My lords, my lady, unless I can assist any further.
Thank you very much, Mr.
those are my
Blundell.
submissions.
Thank you. Yes, now, Mr. Squire.
Yes.
Starting with ground 1,
Yes.
this was an introductory point my own friend made, but it seems to be relevant in particular. That he says he began his submissions. This is an unusual case. She knew about the decision. She makes express statements that she doesn't want to appeal. He also took you in detail through the reprieve letter, as I did, and we respectfully agree entirely. This is an unusual case, and that really is the foundation. I'll come on to ground 1 in a moment, but that is the foundation on ground 1. You do have what appears on any analysis an extraordinary set of actions or inactions by an individual, and our submission is they call for an explanation. And I'll come back to that, how my learning friend then continued to deal with ground 1, but that's, in a sense, we agree about that, and that is ultimately what the sort of bedrock of...
When you say they call for an explanation.
Yes.
That's got to come from...
And the question is whether we gave one, I appreciate, I'll come on to, but certainly once the findings and those facts that my learning friend referred to, we agree, are incredibly striking. And one does, I asked it rhetorically at this stage, but we'll come on to where we answer it. Why? Why did she behave or not act in the way that she did? And I will say, return to that, but that's his introduction. We agree. That's the place to start. Second, my learning friend appeared to make a submission, as we understand it, that she changed her mind about wanting to return home between December, prior to the decision, November, December, and then in January. And he says, well, that's because the citizenship deprivation, or that's he posited as a potential explanation. That is nowhere in SIAC's findings a suggestion that here was someone who, as SIAC found, was making all these efforts, giving this authorisation to attempt to go home, and then at some point in January changes her mind about that. And had SIAC, we say, not made the ground 1 error, that is precisely the kind of thing one might have grappled with. But there is no suggestion in SIAC's findings, and this appears to be a quite new way to put the case, that there was a change of mind about her desire to come home. And to the contrary, SIAC relies on the fact that she is not communicating any change of mind in its findings against her. So if you go back, my own friend took you to paragraph 65 on page 81. This is dealing with her I didn't understand argument. One of the things that's said, and this is the left-full claim that's been handed up to you, one of the reasons for doubting here, fear that repatriation might lead to separation, is that she's written this letter which reiterates, or the letter is written which reiterates her desire to return to the UK with her son. Of course, this letter is sent in late January, so sometime after the deprivation decision, and SIAC's view there, exactly the opposite of what my learned friend says, is, well, you know, it's assuming that she's still communicating the desire to go home. That's why it says there's this contradiction. And then again, when one goes to the authorisation, so we're now in July 2021, again, she's asked and she authorises the repatriation efforts. And again, that is held against her, but there's no suggestion at all that she's ever changed her mind about that. My learned friend took you through the evidence in some detail, pointing out, in effect, the strength of the case against her. But there's no rationality challenge here against SIAC's decision. What the case on ground 1 turns on are 3 things. And I'll say what my learned friend says about them, what we say about them. The first is, was an explanation put forward based on her being frozen, unable to act, that is different from an explanation about not understanding? My learned friend in his submissions placed these all together and said, it's all about engagement. But that can mean 2 quite different things. And the question, the first key question before you on ground 1 is, did the appellant put forward an explanation that she was unable to act, distinct from an explanation that you couldn't understand? Because they are, of course, conceptually distinct. You can understand your citizenship has been removed, but for whatever reason feel paralysed, frozen, unable to take a step, whether you regard it as too daunting to bring an appeal against the government, whether that feels like too much of an action that you would need to think about. And the question then is, are these put forward as separate explanations? And we respectfully say they clearly are. And I took you to the opening of the submissions that were made, as always, very casually by Ms. Mitchell on the appellant's behalf. And I won't take you back through them, but all of them refer to, you have them in your notes, it's inability to engage with information was given, or with the possibility of acting on it. It's always put in that different way. And we do say those are distinct explanations, and the reason we say it comes to the fore once SIAC has rejected the understanding one is precisely because, and this was my rhetorical question, well, why? Why doesn't she then put in the appeal? And we do say there is a separate explanation for that, the only plausible one, certainly it's the only one put forward. So that's the first, if you like, dispute between us. First question. Second question would be, was that explanation considered by SIAC? My learned friend took you to 61 onwards and said, well, look, they deal with engagement, paralysis, etc. But one does need to dig deeper than that, because what they don't do, what he was unable to point you to anywhere where they dealt with this apparent contradiction on their findings, which is someone who understands but doesn't act, and nowhere then looks at the separate explanation that is put forward for that inability to act.
And even if they can understand, they can't act.
Yes.
As a freestanding point.
Yes. Yes, a freestanding. And it's, as I say, otherwise it's very hard to it is very hard to think of another explanation here. If she understands all of this and wants to come home, there has to be some sort of, and it's a psychological explanation. That's why, as I said to my learned friend, it's not going to come from Ms. Foer beyond setting out what happened. It will have to come from Professor Patel. So we say, your second question, is it considered? My learned friend took you to those passages, but nowhere do we see it. Nowhere do we see that point considered, which we say it is part of the explanation and part of what we say calls for some sort of account. What SIAC is dealing with there is in fact quite clear. It's 61 to the key passages my learned friend took you. It's 61 to 65. It's dealing with Ms. Foer's first statement, paras 36 to 42, which is all about, she said she wasn't certain. She said she didn't understand. Nothing about any inability to act. And then the third point, if we're right on the first that she did put forward, right on the second that SIAC didn't consider it, the third question would be, is that an error of law? And I don't think there's a dispute there. I think, as I understand, it's accepted. If it was put forward as an explanation and SIAC didn't consider it, that would be an error of law because it's accepted. It needs to. And of course, we accept it has to be put forward by her, it has to be on the evidence. But if it is, we say it will be an error of law not to consider it. So that's ground one.
I mean, the thing we have to bear in mind, perhaps, in looking at this freestanding point, is that to raise it, it does involve acceptance that you're wrong on your first point. Namely, she didn't understand what was happening in the first place.
Yes, probably. I mean, yes.
Forensically, it's not the sort of argument someone would normally put forward as a freestanding point, because it does cut across what was otherwise a main point.
Well, I suppose in this sense, I mean, maybe this isn't a satisfactory, but human psychology is complicated. We're dealing with behaviour that is, on any analysis, not rational, which is acting contrary to what appear to be her interests and desires.
So, lastly on this, did the psychologist actually look at the scenario of someone who understands the issues, but nonetheless is, despite that understanding, not able to take action?
No, I think my reading of the report is she refers to both. She doesn't refer to it in those sort of terms as being, well, if not one. She says, doesn't understand, frozen. And I think, as I say, and I certainly accept it was put forward as both. Yes. But it seems once one goes, our submission is the other doesn't. And the reason you can have both, you can someone who doesn't want to engage, doesn't understand, but also doesn't want to do anything they have certainly found that she's understood, she's replied, she's used the word citizenship. Why doesn't she appeal? That then does lead to the other explanation. We say it certainly is capable, and indeed makes more sense on its own, but you can have both. But the answer to my launch point, so a very long answer, she doesn't deal with it in those terms. She puts forward both explanations. It's the way the submissions were put was it's this and or in that sort of way. Ground 2, this is, it all turns on paragraph 82 and what it's doing there in the analysis. And ultimately, we say one simply cannot square the circle and say, well, no, this really was another way of talking about credibility. It was, they made the finding of credibility, this was another way of discussing. We say that simply isn't the structure of the analysis. This would make no sense if it had rejected the credibility, is our submission. And in terms of the submission that's then made, which is, well, this is, in fact, SIAC saying this was unreasonable and we've now assessed this particular, we accept this is genuine, or even if it's genuine, we've gone through analysis that says it's not satisfactory. That's simply nowhere in SIAC's decision. I say I have accepted that one could have an analysis that says, well, yes, this is genuine, and then one, but we think that the belief is unreasonable. But what one then would expect is to go and say, well, why does one have this unreasonable belief? If one could accept in principle that an unreasonable set of beliefs could give rise to it being unjust not to extend time, you would have a completely different decision. We say any ordinary reading of paragraph 82 is you stop there simply because it's unreasonable. Because otherwise you'd have, I say, a much more detailed discussion. We say the ordinary reading, which we're invited to do of paragraph 82, is we don't need to go further once we've found it's an unreasonable decision on that possibility. And of course I accept, as my learned friend said, one doesn't look into the mental state for the purpose of the second possibility, but that's very much, they're talking there about the second possibility. This is, she's lying to Ms. Foa, and they then say, well, to work out why, etc. But you then move on to the next one, and the only reason they give for not going further than they do is unreasonable. And we say that the obvious inference from that is they've directed themselves that once you've got there, you don't need to go any further, and that's the error of law. Finally, on the Mabanga point, we respectfully, this isn't a question about form over substance of exactly how one structures a judgment. But if you look at the way in which this is discussed in both of the Court of Appeal cases, it is very much whether you make the decision on credibility in isolation and before you go on to consider the expert evidence. That's exactly what SIAC does at 61 to 67. You don't make those findings have to be made together with, and it's quite clear 61 to 67 are preliminary views on credibility. And if there's any doubt about that at all, and this is why we do say this is clearly Mabanga error, it's those two sentences at the beginning of 67. It's the we have doubts doesn't work because we've got reason to doubt the genuineness. That is precisely, that is identical to the two other cases, is you've reached a preliminary view.
But isn't that after they've considered Professor Patel's report?
Not in the context, certainly not. They've set out that she's produced a report, but not. They don't analyse it in any way in relation to their finding. I think they've obviously where they refer to Professor Patel's.
Well, they must have done.
Yes, I think they.
68 refers to inevitable limitations which we've already identified.
Yes, I'm trying
That's
to
a reference to 51, isn't it?
Sorry, my lord.
That's a reference to paragraph 51, or amongst others, perhaps.
Yes, I see. They start. I think Professor Patel 41.
Yes.
They said he'd go through what she said.
It's not. So you say it's just a summary, do you? Without taking it in.
Well, they clearly don't suggest anywhere in 61 to 67 that they have taken 61 to 65 that conclusion is being reached in the light of what Professor Patel says. So they set out what Professor Patel says. They summarise the evidence, generally going through it at this stage. They then reach the findings of credibility, but there's no reference at all there to reaching those findings in light of what they're entirely separate. They're completely distinct reasons for rejecting it.
I mean, structurally, it's Professor Patel up to 47.
Yeah.
Then Professor Greenberg, which is a critique of Professor
Yeah.
Patel. So within that section, there is reference to challenges to Professor Patel.
Correct. What they don't do is
And,
sorry.
But they don't. Your point is they don't make any findings about it.
So they describe the evidence of all the evidence before them. The key point is when they then come to decide credibility, which is the credibility of the account that Ms. Foer put forward based on what she says she's been told, they don't do it by reference in any way. And I say this is not a form of assumption. They simply do not say.
Where precisely are you?
Oh, 61. So this is where they doubt. This is where they come to what we say is clearly a preliminary view. Doubt the genuineness is 61 to 65.
Yeah, and then they say.
We
don't find any materials in the report of Professor Patel.
Yes. So
that's in the context of having outlined what that report said.
Correct. But what they don't do is anywhere analyse credibility by reference to anything she says, and then it all comes back to I suspect the first two lines of 67. You then give as one of the key reasons for rejecting her evidence as being that they doubt the genuineness. So that must be not by reference to her, ours would be completely circular.
But the position about the report of this expert, which seems to me to be quite different from the situation in Mabanga or Jacto, is that in those cases, as I recall, there was only evidence from one expert who supported the claimant's account of life, whereas in the section we've just been looking at, there's a summary of the points made by Professor Patel, and it is then noted in some detail that there are various challenges to her approach in Professor Greenberg's report. So this isn't a case like Mabanga or the Jacto.
Except nowhere, unless I've missed it, does Professor Greenberg say she's wrong. I mean, he gives various reasons why.
Yeah, but that's the background against which science then goes on when it's sort of expressing its conclusions to say, in short, we reject Professor Patel's evidence for these various reasons because it's just not reliable.
But as I say, but our submission, well, you already have my submission, is that one of the key reasons for doing that is we've already made a decision. That's the only reading one can give.
Well, is it fair to describe it as a decision? They describe it as doubt.
Doubt. But that's exactly what the adjudicator says in, I think she specifically uses the word doubt in how she describes her own views in Mabanga.
Well, your submission might have some faults if that were the only reason, but I think, if I remember, Mr. Bundle said it's one of 8 reasons. So he made, there were 2 submissions against us. One, there's no Mabanga error. Yeah.
We say that is clearly it. Whether there are other reasons, that comes to materiality of the error. So that would be an argument if you were to say, if we strip this out, can we say Psyche inevitably would have reached the same conclusion?
I mean, this is an odd case also, isn't it, in the sense that, for unfortunate reasons, the primary witness didn't give evidence and hasn't been cross-examined.
Yeah.
So what you have is this case proceeding on the basis, as far as her factual account is concerned, on the basis of what Ms. Foer says, and then the expert hasn't seen this person either, and he too, she too, is relying upon the same source, Miss Foer. And in a sense, that's what's going on in 67, because having referred to what are described as doubts 5 lines down, quite apart from that, and then the commission goes through Miss Foer's material as the source for the expert opinion.
But my lord, I accept that. So it's back to if this court was concluded, well, it's in it. Well, if there's no Mabanga error, we don't get anywhere. If there is Mabanga error, that's when this becomes relevant. And the issue the court would have to say is, well, can we say if one strips out the Mabanga error, if it didn't reach a, however one wants to describe it, preliminary review, reasons to doubt, genuineness, is it inevitable that it would have reached the same conclusion about Professor Patel's evidence? And my submission is it's not. If one looks at the rest of, one can give it a number of how many objections there are, but if one looks at them, I'm not sure where we get to that, but they are, one is the fact that she hasn't seen her, and so it's expressed in the terms it is. Well, that's correct, but she is an expert who feels able to say something is highly clinically plausible. There's then, I accept that where the evidence come from Ms. Foer, but again, it's not being suggested, as we understand it, that she's got it so completely wrong that one wouldn't be able to. I mean, one assumes she's given a genuinely accurate picture of what she's been told, and then there's how do you deal with her childhood, age 4 to 17, which forms next to no part of Professor Patel's analysis when she actually comes to her dealing with traumas, etc.
Can I ask, where in this judgment from SIAC do we find the finding of credibility expressed in clear terms, you say, before proper consideration of Professor Patel? And I'm looking, for my part, for a statement similar to how it's defined by Mr. Justice Wilson, as it was, in Mabanga at paragraph 15, where he lists findings by the adjudicator which repeatedly refer to not credible, wholly not credible, etc. Where do we find that sort of strong, my word, statement in the SIAC judgment before assessment is given to?
No, I can't claim we find anything with that strength. It's the way that the evidence is dealt with 61 to 65, and then it's the conclusions. Well, there's good reason to doubt.
Good reasons to doubt, further undermined. I mean, it's clearly going in the direction of not accepting, but it doesn't, for my part, at the moment, seem to amount to the sort of definitive finding against which Mr. Justice Wilson or Justice Buxton warned in Mabanga.
The other main difference between the two cases you rely on and this case is that those were all cases in which the claimant or appellant in the tribunal had given evidence. So they'd given evidence to the court, and this is not a case where the appellant's given evidence. So it's all at several removes.
No, I mean, of course, I entirely accept that. But what Professor Patel does give evidence on is her paragraph 57 is particularly about how you would end up with someone able to read a letter like the reprieve letter and respond in the way she did and not be able to understand. That's what Professor Patel says here. For all these reasons, that's her conclusion. Why I find it clinically plausible.
I mean, looking at the structure of the judgment, one could well imagine by the time we get to 66, although doubts have been expressed, if the evidence has gone the other way, or Professor Patel's evidence has been accepted, it could easily, one could imagine saying, on the other hand, there was the very strong evidence of Professor Patel. It's not, at the moment, to me, it doesn't look as though there's a definitive finding prior to 66, which puts this case in the Mabanga category.
Yeah, but it's also the.
That's my. I mean,
I view about it. I mean, and if I can't satisfy, well, what I need to satisfy you with to be in that category is they've expressed a preliminary view. I think that is Lady Justice Smith's language in Jacto. You shouldn't even express a preliminary view on credibility and precisely here, because the experts' evidence goes to the question of credibility that you are deciding. And as I say, you then reject it. And we do respectfully say, well, our submission is, that is a preliminary view. Good reason to doubt the genuineness is certainly a preliminary view of its genuineness. And in fact, they don't go further to make any more findings. In fact,
so this is you took us to earlier, didn't you? It's in Lady Justice Smith, is it?
yes.
It's flagged.
But paragraph 28, page 21 of the authorities.
Yes, it's 31, I think, is where it says even provisionally. In the present case, my judge, I should not have found the facts even provisionally. I think what the judge did is 26. He made some preliminary findings of fact.
Wow.
I mean, the other thing the other thing I would say about this judgment is there's nowhere else where they make findings of fact. It's not that later on they say, and now we're able to make our certain. That is it. I mean, it is that 61 to 60. That is where they're making factual findings.
Well, again, I mean, we'll have to consider, but it could be argued that by the end of 65, SIAC had definitely, it had certainly referred to Professor Patel's evidence, so it certainly had considered it, and considered the criticisms of it by Professor Greenberg.
Yes, I mean, they certainly described it. The question is, do they then, when they undertake this analysis, 61 to 65, are they doing it in the light of that, given that she gives evidence? And our submission, given what they then say at 67, is clearly not the analysis. But you have my submission.
Well, we've interrupted you a lot.
No.
Mr. Scribe. Of course, we know we're just testing your
No, I'm grateful.
Forgive us for doing that, interrupting you. What else do you want to say?
No, I think. Well, or nothing.
Thank you. Anything else? Well, thank you both. We're extremely grateful to you and to both of your juniors, Miss Mitchell as well as Miss Parsons, and to those who sit behind you for the very professional way in which this case has been presented, both today in court and in preparation. We're going to reserve our judgments in the usual way. In due course, you will receive a draft of our judgments. That will enable you to make typographical corrections and minor errors of fact, not an opportunity to re-argue the case, of course. Please bear in mind the embargo at the top of the judgment, and it's confidential and must not be disclosed. The draft must not be disclosed beyond those to whom it is allowed to be disclosed. Breach of that embargo would unfortunately be a contempt of court. We'd be grateful if you would supply a draft order when you've had our judgment. Any disagreement between you as to the terms of that order will resolve in writing on the basis of brief written submissions. We'll then arrange for judgment to be handed down electronically in the new way, so there'll be no reason or need for you to attend. Thank you very much.